Welcome to the final four of the largest ever international mock trial league contest. We began with 48 teams, and now we are down to the semifinal round. We have a very prestigious and esteemed judging panel for you here to determine who moves on to the finals. And we're going to begin with the coach of Fort Lauderdale High School, the coach of the Gladiator, meaning the top high school student in the world. That is our presider, Judge Anito Simon. Sir, the honor is ours. Please take it away.
All right. I'm excited. I'm excited. Always fun to do these championship rounds of IMT mock trials. Some of the best mock trials out there. Name is Janito Simon, coach from Fort Lauderdale High School. Looking forward for you all to steal the moment. Looking forward for you all to have fun. Looking forward for you all to argue the rules of evidence like gladiators that I believe you all are. And looking forward to a phenomenal round. I have two esteemed judges with me who will also introduce themselves. First and definitely foremost, because he's done the most amount of mock trial rounds, I believe, in IMT, except for maybe Josh Deng. We have Steven Noodleman.
Hi, everybody. Steven Noodleman here. I am a practicing lawyer. I'm a partner in a 100-lawyer firm based in New Jersey. And as Judge Simon pointed out, I've been judging mock trial for the past, 10 years, including the IMT and some AMTA, including I have an ORCS thing coming up in another week. And I really enjoy it. I think that I agree with my fellow judges, have a good time. And we're expecting a great show.
All right, and we have Judge Dee Ross of the USF mock trial team, where she's competed in high school as well as college, and she's done a lot of rounds in this competition. I'll let her tell a little bit about herself. Judge Dee Ross?
Hey guys, I feel, Judge Simon kind of already said everything, but yeah, I've been competing for the past 5 years. I go to USF. I mostly play witnesses, but I've also done lawyers before, so like I know both the sides. Yeah, I'm excited to judge y'all.
All right, with that, let's take it away. Prosecution, are you ready?
Yes, Your Honor, we're ready.
Defense, are you ready?
Yes, Your Honor, we're ready to get this show on the road.
All right. Can I get appearances, please? Prosecution first.
Good evening, Your Honor. My name is Pranamya Aditham, and alongside my co-counsel, Mr. Hong,
Good evening, Your Honor.
Good evening.
we represent the people in today's case. After the defense introduces themselves, we have some housekeeping matters we'd like to address.
All right. Let's get appearances, please. Defense.
Yes, Your Honor. Hello, Your Honor. My name is Christiana Garcia, and today I'm joined by my friend and colleague, Elizabeth Liu.
Good evening, Your Honor.
Good evening.
We're also joined by our legal intern today, Ethan Bai.
Good evening, Your Honor.
And good evening.
Mr. Bai is going to be taking care of all those technical things we have going on behind the scenes as we represent our client, Nova Wölff, in today's matters.
Good evening, Your Honor.
Good evening. All right. With introductions being done, prosecution, you promised me some housekeeping. Let's go.
Yes, Your Honor. We would like to invoke Rules 603 and 615, constructively swearing in and sequestering all witnesses barring party representatives.
All right. Prosecution, do you have any exceptions or exclusions to Rule 615?
Your Honor, we would just ask that we designate our own party representative as Nova Wölff.
Okay. Defense, give me a minute, but prosecution first. Do you have any exceptions or exclusions?
No, Your Honor. We would also like to designate Miss Ashlock as the people's representative at this time.
All right.
Good evening,
Understood.
Your Honor.
Good evening. All right, defense. You mentioned Ashlock or Wolf as obviously the party. Any other exceptions or note to anything noteworthy to take into notice?
No notes, Your Honor.
All right. Anything further, prosecution?
Yes, Your Honor. Since this is our first time performing in your courtroom today, we'd like to ask Your Honor's preferences when it comes to screen sharing documents. Should we ask your permission before screen sharing or simply have the record reflect it?
Just let the record reflect.
With that, the people are ready to proceed to opening statements.
All right. Before opening, prosecution, any housekeeping matters from you all?
Yes, Your Honor. First, we'd like to put the court to notice that we'll be pursuing an affirmative defense today called a citizen's arrest.
Okay, understood.
We'd also like to bring the court's attention to Stipulation 11, which states that Nova Wölff is a private detective certified by the Tilly Detectives Association.
Okay, prosecution, anything worth noting there?
No, Your Honor.
All right, anything further, defense?
Yes, Your Honor. With that in mind, we'd actually like to bring the court's attention to a case law, Tilly v. Swift. As we can see on screen, it sets a precedence that licensed private detectives are not compelled to cease investigations when instructed by law enforcement, so long as those investigations independently do not violate the law.
Understood.
Lastly, Your Honor, we'd like to bring the court's attention to the fact that during our meet and confer with opposing counsel, we both agreed to pre-admit Exhibit L6, which is a photo of the knife used in this case.
Okay, it'll be so admitted. Anything further?
No, Your Honor, we're ready to go.
All right, prosecution, opening, please.
Yes, Your Honor. The investigator became the perpetrator. It's March 11th, 2025. Cotter Ashlock is peacefully walking the streets of Corleone in search of justice. That's when someone comes up behind her and knocks her out cold. You'll hear how next she knew she was in an unknown basement, bound to a chair with duct tape over her mouth. And you'll hear that she was relentlessly interrogated. You'll learn that the person who kidnapped Miss Ashlock was the defendant, Nova Wölff. That's why we as people are charging Nova Wölff for unlawful imprisonment and interfering with an officer. To prove unlawful imprisonment, we have to show that Nova Wölff intentionally restrained the victim, causing an interference with the victim's freedom of movement, and that the restraint was without the victim's consent. Additionally, to prove Wölff was interfering with an officer, we have to show that she intentionally obstructed the officer while they were performing their duties, and that the defendant knew the officer was performing official duties. Members of the jury, we have to prove these charges with a burden, beyond a reasonable doubt. Not beyond all doubt, just what's reasonable. And we'll meet that burden by showing you how Wölff's actions were intentional, inhumane, and illegal. First, her actions were intentional. Both sides agree that Miss Ashlock violated her parole terms, and she'll take the stand today and own up to that. But what you'll also find out is that when the defendant took Miss Ashlock captive, she wasn't driven by any real concern for the law, but by revenge. Cotter Ashlock will tell you that one of Wölff's best friends was killed because of the Ashlock family, resulting in Wölff's growing resentment. She'll tell you about the constant stream of ominous notes and emails sent to the Ashlock family following her friend's death. You'll hear how she knew the plan, knew the history, and knew exactly what she was doing. Second, her actions were inhumane. You'll hear how the defendant tied Miss Ashlock to a chair and duct taped her mouth. But that tape wasn't there for long. You'll hear how Wölff wanted information from Ashlock, information that could indicate who was behind the murder of her best friend. You'll hear through a video transcript that Wölff had been interrogating Miss Ashlock about a person she believed was connected to her friend's death. You'll hear how she wasn't planning on calling the police until she got the information she wanted. You'll see that her actions did not help the police but obstructed them. And finally, her actions were illegal. You'll hear that she failed to call the police in a timely manner. In fact, the evidence will show that Wölff threatened to call the police on Miss Ashlock if she didn't answer her questions. questions used to pursue the defendant's own revenge. It'll become very clear to you that she had no intention of helping the police, and her so-called detainment only obstructed them further. That's why at the end of today's trial, my co-counsel, Mr. Hong, will ask that you find Nova Wölff guilty for her actions because they were intentional, inhumane, and illegal. Thank you.
Thank you, attorney. Attorney for defense, will you have an opening or wait for case in chief?
Your Honor, we'd like to do our opening statement now.
Okay, you may begin.
She captured a criminal to stop a crime. A criminal named Cotter Ashlock stands feet from the home of investigator Nova Wölff. She's not there by coincidence. She's there to commit a crime against the investigator who put her entire family behind bars. Today you'll learn that minutes later, investigator Wölff hears a disturbance outside. Unsuspectingly, she steps into the darkness. When suddenly, that criminal reaches into her jacket, pulls out a knife, and lunges to attack her. In that moment, investigator Wölff has a choice: die or fight for her life. Today you'll learn she chooses to exercise her lawful right to self-defense, disarming, detaining the criminal who was trying to attack her until the police came. Because today you'll learn the investigator didn't become a perpetrator. She became a protector. And today you'll learn that when the state chose to charge her with 2 felonies, they took on the highest burden in our legal system, proof beyond a reasonable doubt. Now, today, we're confident they're not going to be able to meet that high burden. And that's why we've brought forth something called an affirmative defense of a citizen's arrest. Now, let me spare you years of law school. Simply put, we have to prove it's more likely than not she witnessed a crime, she used reasonable force in her capture, and she contacted the police within reasonable time. And if we do, you must find her not guilty. And today, we're going to meet our burden by proving 3 facts: the crime, the capture, and the contact. First, members of the jury, we're going to talk about the crime. Today, you'll hear from a resident of the neighborhood that she heard Miss Ashlock pull out a knife when speaking to investigator Wölff. Today, the evidence will show that the only DNA on that knife solely belonged to the defendant, or rather, solely belonged to Miss Cotter Ashlock. So second, the capture. With this fact, you'll learn every citizen has the right to defend themselves using reasonable force. Now, that doesn't mean being as gentle as possible. In fact, the evidence will show that investigators Wölff's actions of disarming the criminal, tying her up, and keeping them in her home, unlike the state wants you to believe, was completely reasonable to prevent a further crime. So lastly, folks, you're going to learn she contacted the police. Because unlike the state told you, reasonable time doesn't mean calling right away. It means calling as soon as possible. You'll learn that investigator Wölff did that. As soon as Cotter Ashlock stopped threatening her, she got the opportunity to call the police and tell them that she captured a criminal to stop a crime. Because today, when the state told you she knew the accident and she knew what she was doing, you're going to learn that they were wrong. Because when you take the time to look at the knife, the DNA, and the timeline, you'll see that she was acting on self-defense, not revenge. And today, as jurors, we'll ask you to act in a way that serves justice. And when you do, we expect that you'll find her guilty. Because she captured a criminal to stop a crime. I appreciate your time.
All right, prosecution, are you ready with case in chief?
Yes, Your Honor. The prosecution calls Officer Larry Capolino to the stand.
Good
Actually,
evening,
let's
Your Honor.
before beginning prosecution, let's give it a moment and I'll wait for my jurors to give me a thumbs up when they're ready.
Of course, Your Honor.
All right. Prosecution, you may proceed.
Yes, Your Honor. Good evening, Officer Capolino. Could you
Good
please
evening.
could you please introduce yourself to the members of the jury?
Well, hello. My name is Officer Larry Capolino.
Officer Capolino, what do you do for a living?
I'm a sworn officer with the Corleone Police Department, or the CPD.
Could you tell us a little bit more about your work?
Yes. Well, I have served with CPD since 2011, and after graduating from Maple Police Academy, I participated in over 50 felony investigations, which involve organized crime and violent offenses. But outside of this job, I really enjoy photography, and it helps me slow down and notice more details, light, shadows, and small movements, things other people might miss.
How are you involved in today's case?
I'm the lead investigator assigned to the case involving Cotter Ashlock's alleged kidnapping and assault on March 11, 2025.
Let's move on to the case at hand. Do you know who Cotter Ashlock is?
Yes, Cotter Ashlock is a former member of the notorious Ashlock family. And then the Ashlock family has been one of the most menacing crime syndicates in this region since the late 1980s. Well, they're pretty infamous for heinous acts such as murder, extortion, bribery, poisoning, and racketeering.
And do you know who Nova Wölff is?
Yes, I first encountered Wolf in 2018 during a series of investigations into Ashlock run operations. Well, Wolf, unofficially unsolicited, began supplying anonymous tips about Ashlock's safe houses and laundering fronts. Although some leads were useful, Wolf's actions were mostly reckless. Well, they did things in their own way, and I suspected that they had more than one motive.
Well, why would you think that?
Well, you see, someone named Mark Wolff, a close friend of Wolf, and was poisoned in an incident tied to the Ashlock. And after that incident, Wolf has skirted legality repeatedly in her pursuit of the family.
Objection, Your Honor. As to 404 improper character evidence.
Also,
Your Honor, this witness just testified that Investigator Wolf has repeatedly, recklessly bordered the line of legality. Your Honor, in this case, we have a good faith belief the state is using this to prove propensity, saying that she bordered on the line of legality before. She's going to border on that line again. Your Honor, it's textbook 404.
Your Honor,
counsel
if we
for
may respond.
prosecution. Yes, response.
Your Honor, this is not character evidence, as we are not using this to show that she would act in one way or another. We're merely, what my witness here is doing, she's merely restating her relationship with the defendant, Detective Nova Wölff.
Response, Your Honor?
Yes.
Your Honor, if that truly were the case, then Mr. Hong could have stopped this line of questioning at I encountered Investigator Wolf throughout a series of investigations. But for this witness to go further into repeatedly being reckless, repeatedly bordering the line of legality, Your Honor, certainly that suggests propensity to the members of the jury, and it's character evidence.
Yeah, counsel, I'm not quite sure I can read the intent into it, but it does seem like prior bad acts, and you're not giving me any other reason it's coming in. You last word, counsel for prosecution.
Yes, Your Honor. Character evidence is inadmissible for criminal acts, and these are not since because we are not stating that she has done criminal acts before, that she will do these criminal acts again, because she has done no criminal acts in the past, and because we are not using this to state that she is more likely to act in one way or another, we are merely stating this witness is merely stating her relationship and her views of Detective Nova Wölff to explain her actions on why she was so concerned uh, when she heard that Miss Ashlock had been released on parole.
Yeah, I'm gonna sustain the objection. I think the rule says other wrongs, crimes, or acts, so I don't think it has to be just crimes. I think other acts, wrongs also is applicable here, so I'm gonna sustain the objection.
Yes, Your Honor. Motion to strike the offending testimony.
So stricken. Jury, please disregard the witness's testimony and do not consider it in your jury consideration.
Yes, Your Honor.
Yes, Your Honor. Officer Capolino, let's walk through what happened that day. What was the first thing of interest that happened on March 11th?
Well, at around 10:50 p.m., I was about to go off shift, and Nova Wölff, she finally called me back. Oh, I had called her 5 days before, but she hadn't picked up. And this time, I told her again that Cotter Ashlock was released on parole last week. I also advised Wölff not to take any action on Ashlock. Wölff refused to do so and said, "I don't take any orders from you, inspectors."
Was that all she said to you?
Well, I heard some crashing noises from the other end of the call. I asked what was happening and just heard more crashing noises. And then she hung up on me. Later that day, we had an incident involving Cotter Ashlock at Nova Wölff's residence.
What was the incident?
Well, at 11:35 p.m., our dispatch received a call from Nova Wölff, and Wölff reported that a known criminal had trespassed on their property and was currently being held in their basement, waiting to be picked up.
What did you do after receiving the call?
Well, you see, like I mentioned before, I tried to take in the whole picture before making any conclusions, and due to the nature of the report, the call I received from Wölff and her previous history with the Ashlocks, I responded personally with a team of officers.
What did you do when you arrived?
Upon arrival at Wölff's residence, we found Cotter Ashlock, disheveled, bruised, and seated on a basement chair with her hands untied but visibly shaken. And Wölff, she was standing nearby and gave a brief account of events. And we removed Ashlock from the premises and placed her in a patrol vehicle.
Did you run any interviews?
Yes. Well, during the ride back to the station, I questioned her directly, and Ashlock alleged they had been abducted while walking through Corleone town. And she also said that they were struck from behind, tied into a chair in a dark basement, and interrogated by Nova Wölff. And Ashlock said Wölff demanded to know the location of Jay Kuang and threatened Ashlock with a knife, in addition to smashing Ashlock's phone.
Is that all she said to you?
She also said that she was kidnapped at around 10 to 10:30 p.m. And if Miss Ashlock was telling the truth, that means that Wölff was lying to me when she said she didn't know anything during our call. And lying to a police officer during an investigation is illegal.
Objection, Your Honor. Under case law, Your Honor, under
Yes,
Rule
what's the
403,
basis for the objection?
Your Honor, under Rule 403, more misleading than it is probative.
Okay, please explain.
Yes, Your Honor. Under case law, Kolosky versus Tilley in 2025, it is in violation of a citizen's Fifth Amendment right to suggest or state an adverse inference against a defendant for refusing to provide statements. Your Honor, in this case, Officer Capolino going into the illegality of Investigator Wölff not volunteering information is certainly violating the precedent that Tilley set in 2025.
Your Honor, if I may.
Yeah. Yes.
Your Honor, I believe in the same case law. Your Honor, this if I may pull up the name. According to Permit Office Enforcement v. Citizens for No Permit Office Enforce wait, no, not that one. In Tilley v. Foundation for Poisoning Pigeons, it clearly states that to interfere with an officer, the false statements must obstruct the officer's ability to continue with the investigation. If she truly had been kidnapped at around 10 to 10:30, then she would have known the exact location of the defendant, yet not volunteering that information to police authority would be a crime under would be um, interfering with an officer according to that case law.
Counsel,
Response.
no, counsel for defense, yes, but specific to my question is, I hear the witness testifying that she spoke with the defendant, and the defendant, based on something else somebody told her, she believed what the defendant originally said was a lie. I don't think we're having conversations about the Fifth Amendment here and the witness not answering. She's just saying the answer given by the witness might be inconsistent based on other things she learned. How is that commenting on somebody's Fifth Amendment?
Yes, Your Honor. The case law says that it is in violation of the Fifth Amendment to refuse to provide a statement. This witness just testified that investigator will fail to provide the truth, fail to provide the truth during that interview, that indeed Cotter Ashlock was in that basement. Your Honor, her making that inference, in which I have a good faith basis, she's going to launch into the illegality of such statements. Your Honor, that's in violation of that Fifth Amendment right.
Your Honor, if I may.
I'm overruled because I'm unclear as to if that is actually what's happening. Because I don't, what you're saying, proffering, is I don't think is what I heard. I heard she said your client said something and then found out something else is the truth. Not that your client refused to answer it. Therefore, she must have been lying. I think it's a subtle difference. And if I'm wrong, please re-raise it. So I'll overrule it, but without prejudice for you to bring the issue back up.
Understood, Your Honor.
Yes, Your Honor.
Yes, you may proceed, counsel for prosecution.
Let's continue, Officer Capolino. What else did you do at the house?
Well, our search team, we did a thorough sweep of the house and in the basement. And in photography, you adjusted the lens until the picture become clear. And we discovered roll fragments and a damaged chair with red residue. And afterward, I sent medical report on Ashlock.
Would you recognize the copy of that medical report if I showed it to you in court today?
Yes, I would.
Your Honor, let the record reflect that we'll be screen sharing what has been pre-marked as Exhibit 9. Do you recognize this exhibit?
Yes.
Is it a fair and accurate copy?
Yes.
Your Honor, we motion to enter Exhibit 9 into evidence.
Any objections?
No, Your Honor, we intend to cross on it.
All right. I'll allow it.
Yes, Your Honor. What did you notice in the medical report?
Well, she had roll burns on her wrist and was dehydrated. I took that to mean that she had been tied down and couldn't drink water for a while. And interestingly enough, she didn't have any head injuries. But the fact that the rest of the evidence matched up was enough to convince me that she was telling the truth.
Well, what did you do next, Officer Capolino?
We conducted a formal interview with Nova Wölff and consequently arrested her because she wouldn't answer any of my questions, and I had a reason to believe that her detainment of Cotter Ashlock.
At this time, I'd re-raise my objection.
Yeah, I think now might
Your Honor,
be commenting on somebody's right to remain silent. What say you, prosecution?
Your Honor, this witness here already had the reasonable suspicion of the defendant, Detective Nova Wölff, and she went to her with her questions of suspicion, and because she did not answer those questions and she didn't defend herself, she's merely stating that because of this, she arrested her, not because of her silence.
Yeah, I'm not sure I see a distinction in what you're saying here, counsel for prosecution. You're saying that they're allowed to use the silence as evidence of culpability, which I think is what the Fifth Amendment is supposed to protect, right? It can't
Your Honor, if I may.
Yes.
Your Honor, we are not stating that her silence was evidence against her. We are merely stating that there was suspicion against her, completely unrelated to her silence, and because she did not defend herself, and because she did not volunteer any volunteer any explanation to Officer Capolino to dispel that suspicion, she arrested her under the grounds of her suspicion of the improper detainment.
Response, Your
Understood, counsel for prosecution. Counsel for defense?
Yes, Your Honor. I understand the distinction Mr. Hong is making, but unfortunately, that's not what this witness testified to. This witness said something along the lines of, I arrested the defendant because once I interviewed her, she refused to provide me explanations or reasons as to why something happened. Your Honor, that's textbook violation of the Fifth Amendment. It doesn't go towards raising suspicions, Your Honor. This witness clearly testified she made the arrest predicated on the fact that Investigator Wölff failed to answer some questions. Your Honor, under Klosky v. Tilly, that's not allowed.
Yeah, I think, yeah, I'm going to sustain the objection. That's commenting on somebody's right to remain silent. I'm going to sustain that objection.
Yes, Your Honor, motion to strike.
So stricken.
Yes, Your Honor, we'll rephrase. I'll re-ask my question. What did you do after receiving the medical report?
Well, sorry. We conducted a formal interview. Wait, sorry, can you repeat your question?
Of course. What did you do after receiving the medical report?
Sure. We conducted a formal interview with Nova Wölff, and I consequently arrested her because I had reason to believe that her detainment of Cotter Ashlock was unlawful.
Would you recognize the transcript of your interview if I showed it to you in court today?
Yes.
Your Honor, let the record reflect that Exhibit 1B is being screen shared. Do you recognize this document?
Yes.
And is it a fair and accurate copy?
Yes.
Your Honor, we motion to enter Exhibit 1B into evidence.
Any objections?
No objections, Your Honor.
All right, so offered, so admitted.
Yes, Your Honor. What did the defendant say to you?
Well, firstly, I asked how she kept Cotter Ashlock in her basement. Well, she claimed Cotter Ashlock was there voluntarily, even though we found rope in the house. And I asked how Cotter Ashlock had ended up in her basement. She just responded that she wouldn't waste any of her energy to carry Ashlock down the stairs.
Was that all she said to you?
Nope. When I asked whether Ashlock had trespassed or had been detained outside, she merely responded, yes. It felt like she was intentionally avoiding my question.
Did this help your investigation at all?
Nope. In fact, I was mostly confused with more questions than answers.
Thank you, Officer Capolino. No further questions, Your Honor.
All right. Cross?
Yes, Your Honor. Hello, Officer Capolino.
Hello.
The last thing you told the members of the jury on direct was that Investigator Wölff withheld information, right?
Yes. Maybe. Yes.
You think that constitutes interference?
That's a yes to your question.
At this time, Your Honor, we bring the court's attention to case law State versus the Foundation for Poisoning Pigeons, 2025. False statements to law enforcement only constitute an interference if said statements harm the police's ability to perform a task. Your Honor, the exact wording's on screen.
All right, what am I supposed to do with this information exactly outside the presence of the jury?
Your Honor, we'd ask for this to be a jury instruction.
Okay. At the appropriate time, I'll instruct the jury. Counsel for the prosecution, what say you in regards to this being instructed to the jury at the appropriate time?
Your Honor, we fully agree. For this case law be shown to the jury.
Well, we're not going to show them the case law, but we're going to add a specific instruction in the jury in the jury instructions as to whether or not false statements constitute interference, or what the situation would be where it constitutes interference. All right, you may proceed, counsel.
Ma'am, it's true that a week before Cotter Ashlock was detained, your police department got a call, right?
Yes.
You got a call that Cotter Ashlock broke parole.
That's true.
You know Cotter Ashlock, as you mentioned a moment ago, she's a dangerous criminal, right?
Well, she is.
But for a week straight, your department just couldn't figure out where this known criminal was.
Yes, so that's correct. So I notified that Nova Wölff not to take any action.
And ma'am, after you notified Investigator Wölff of that, she didn't hurt your investigation, did she?
No, she said she will defy me.
Ma'am, I'm not asking about Investigator Wölff's words. I'm asking about her actions. And it's true. She helped you with your investigation.
Well, not at the time. Well, sometimes she did help, but not at that time.
Ma'am, it's true that Investigator Wölff, she was the person who turned that known criminal into the police, right?
That's correct.
She was the one who finally captured that criminal.
Well, yes.
Moving on, ma'am. You're the lead investigator in today's case, right?
Yes, to your question.
A moment ago, you told the members of the jury something very interesting. I wrote it down right here. You said, I try to take everything into consideration in the full picture, right?
Of course.
Ma'am, that's not what you did in this case, is it?
Well, I'm not
Objection, Your
sure.
Honor, as to argumentative.
How so?
Your Honor, opposing counsel has made an argumentative question as to that's not what you did in this case. Did you? Wait, I believe. Oh yeah, could you please restate your question one more time, please?
Your Honor, if I may.
You may.
Your Honor, I said that's not what you did in today's case, correct?
In Your Honor, we believe that to be an argumentative statement.
Maybe, but if the witness knows, she knows. If she doesn't know, she doesn't know. If she agrees, she agrees. If she doesn't agree, she'll let us know. I'm gonna overrule.
Yes, Your Honor. Ma'am, you didn't take everything into the full picture today, did you?
Oh, I'm not sure what you mean. Can you elaborate?
No worries, ma'am. I'd like to talk about whether or not your investigation ignored all of the signs pointing to Cotter Ashlock. Because you'd agree with me, there are signs that Cotter Ashlock committed a crime.
Oh, sure. By violating parole.
And ma'am, she didn't just violate parole, did she, ma'am?
Well, I'm not sure what you mean again.
Ma'am, you keep telling me you're not sure. Surely you know that a moment ago, you showed the members of the jury a medical examination, right?
Yes.
You'd recognize that examination right now?
Of course.
Stating for the record, Your Honor, we'll be screen sharing Exhibit 9, which has already been admitted on the direct examination of this witness. Ma'am, a moment ago, you said that the words on here were enough to prove to you that Cotter Ashlock wasn't lying?
Wait, sorry, can you please repeat your question?
No worries, ma'am. A moment ago, you told the members of this jury that the words on this report were enough to convince you Cotter Ashlock, she wasn't lying. That's what you said, right?
Yes, of course.
Well, ma'am, I want to look a little bit clearer into that. Because on this report right there, it says, no contusions to the head were found.
Well, yes, but even though we didn't find any head injuries, but we did find some bruises on her body through medical examination.
Exactly, ma'am. Those bruises, they were on her knuckle, right?
Yes.
And if you look on screen, that says contusions to the right knuckle indicates punching someone.
Yes.
But ma'am, you didn't ask why those bruises were there.
Well, no, not at all.
You didn't ask Cotter Ashlock whether or not she punched my client.
Well, not at that time. It was enough information for me.
Ma'am, you saw evidence of bruises and you didn't think to ask what they were from? Is that what you're telling us?
Well, there were violence definitely involved.
Ma'am, I'm not asking you about overall violence. I'm asking you about the bruises found on Cotter Ashlock's knuckle. Truth is, you never asked her anything about them.
Well, as I stated again, there were violence definitely involved, so we didn't look further, and there are enough evidence at that time. But yes, to your question.
All right, ma'am. So sounds like from everything you just told me, you can tell us whether or not Cotter Ashlock attacked Investigator Wölff.
That's correct.
Moving on, ma'am. Let's talk about whether or not you missed another sign of Cotter Ashlock committing a crime. A moment ago, you mentioned you like photography, right?
Yes,
You,
that's correct.
You took pictures of the physical evidence, right?
Well, yes.
But you didn't show us a forensic report of that physical evidence, did you?
Well, yes.
I want to show that report to the members of the jury and see why the state decided not to show them that report. Stating for the record, Your Honor, we're screen sharing Exhibit 11. Ma'am, this is the forensic report found of the physical evidence, correct?
That's correct.
Seems fair and accurate since the last time you've seen it.
Yes.
And you'd agree with me, ma'am. You were the one who sent the evidence to make this report, right?
That's true.
You know that making forensic reports, that's a regularly conducted activity of your police department?
Of course.
In this report, right there, you see a case number, right?
Yes, I do.
It was kept in the forensics department, correct?
That's right.
At this time, Your Honor, we move to enter Exhibit 11.
Any objections?
No objections, Your Honor.
All right, I'll allow it.
Yes, Your Honor. Ma'am, this report looked at fingerprints, right?
Yes.
I'm looking for a number here, ma'am. How many fingerprints of my client did you find on any physical evidence?
Well, it's 0.
And if you read right there, ma'am, all fingerprints match those of Cotter Ashlock.
Well, yes, the forensic report did state that there are only fingerprints on Cotter Ashlock, but however, there might be a possibility that Nova Wölff was wearing a glove while holding their phone or a knife.
Hold up, Officer Capolino. That's your sworn testimony to the members of the jury? There were gloves involved?
No, but there might be a possibility. We're not sure.
So, ma'am, you're not sure about the physical evidence you collected?
Well, as I stated again, there might be a possibility of Nova Wölff wearing gloves during.
I want to make this sure for the members of the jury. That is your sworn testimony, right, ma'am?
No.
So, ma'am, yes or no, there were gloves found at the scene of the crime?
That's a no to your question.
Let's get this clear. There were no gloves ever found.
No.
But a moment ago, ma'am, you can't even be sure of the physical evidence you collected. That's what you told me a moment ago.
Yes.
You can't be sure of your evidence. With that, detective, I have no further questions.
All right. Counsel for prosecution, what say you?
Yeah, Your Honor, we're ready to move on to our next witness.
All
And
right.
we're willing to let this witness step down from the podium.
Okay, let's give it a minute. Um, let's give it a minute, and I'll get a thumbs up from my jurors when they're ready. All right, give me 1 second. All right, please call your next witness.
The prosecution would like to call Cotter Ashlock to the stand. Good evening. Please introduce yourselves to the members of the jury.
Good evening. My name's Cotter Ashlock.
What do you do for a living?
I've done work connected to the Ashlock family in the past. I won't pretend otherwise, but I don't exactly call them my family now. I mostly keep to myself. These days I've been raising pigeons. I like to imagine myself as the bird lady from Home Alone 2, but hopefully less scary.
Why'd you choose to raise those pigeons?
You see, pigeons are loyal. You feed them, you show up, and they come back. Raising them was my way of turning over a new leaf and choosing a calmer, more grounded way of life.
How were you involved in today's case?
I was the one kidnapped and held hostage in Nova Wölff's basement.
Let's step back a bit. Could you explain who Nova Wölff is?
Well, you see, Nova Wölff is rather infamous with the Ashlocks.
Infamous? What do you mean by that?
It's a long story, but it all starts with my cousin, Jaden Ashlock, or I think he goes by Jay Kuang now. He helped the Ashlock with the murder of Mark Volkovic and then used it against the Ashlocks.
How does Jaden Ashlock relate to Nova Wölff?
Well, Mark Volkovic turned out to be Wolf's friend, and ever since she found out, we would constantly get sent threats.
Would you recognize an image of these threats if I showed them to you?
Yeah, definitely.
Stating for the record, my co-counsel will now be screen sharing what has been pre-marked as Exhibit 7.
Okay. Do we have exhibits? Is it Exhibit 7?
Yes, Exhibit 7. I believe my co-counsel will be screen sharing it. Okay. Ma'am, what have I just displayed on screen?
That's the picture of a note sent to us.
Is it a fair and accurate copy?
Yeah.
Has it been changed or altered in any way?
No, doesn't look like it.
The people offer Exhibit 7 into evidence.
Objection?
Objection as to lack of foundation.
All right. What foundation you believe is missing?
Your Honor, up to this point, she hasn't laid any foundation as to who wrote this note. We can simply see that that's the initials of NW. However, there isn't any verifiable pieces of evidence that's been laid on the record, whether or not she saw Miss Wölff write this, whether there was any sort of, person who, like an expert who checked whether or not this was actually Nova Wölff's handwriting. They haven't laid that foundation on the record. So right now, they're just speculating as to who wrote the note.
Counsel for prosecution?
Your Honor, if we may proffer, we'll be establishing this foundation later in direct.
All right.
Will be heard.
You may.
Your Honor, it's our contention today that Nova Wölff did not write this piece of evidence. Hence, we don't believe they will be able to lay the sufficient foundation to then enter it by preponderance of the evidence that this was in fact written by Nova Wölff. If they want to try it out now, they can, but we don't believe they will be able to.
Well, they're saying they are, so I should take them at their words. Not sure what to do here. Counsel for prosecution, what say you? Last word.
Your Honor, we will be establishing the foundation later on in our direct. If opposing counsel could just let us finish the questions related to this exhibit, they would see the foundation that we'll be laying.
Your Honor, may I be heard?
Last word.
Your Honor, if that's what they're saying, we'd be happy to allow them to explore that line of questioning, but until that foundation is laid, we can't let this piece of evidence in.
But I think I can. We're gonna conditionally accept this piece of evidence under, I don't know the rule. I feel like it's like 105 or something. We're gonna conditionally accept this rule of this evidence until and unless the foundation's made. If at that point you feel the objection is the foundation's not made, then we can revisit whether or not we should strike the whole thing right now. But I'm going to conditionally accept it, and the condition that at some point later on in this direct or this case, the foundation is laid.
Yes,
All
Your
right.
Honor.
Please proceed.
Ms. Ashlock, could you please read what the note says?
Sure. It says, I will hunt you down to the corners of the earth if it's the last thing I'll do. Signed by NW, which is Nova Wölff's exact initials.
Ma'am, did you receive anything else with this note threatening to hunt you down?
Yeah. Inside the same package was a knife covered in what looked like blood.
Did the threats end after that?
No, it didn't. We were also receiving concerning emails with a similar username alongside all these notes.
What was in those emails?
The emails included private and intrusive photos of us that were sent to us every single day.
Would you recognize one of those emails if I showed it today?
Yeah, and definitely. Those emails still haunt me.
Let the record reflect that my co-counsel will now be screen sharing what has been pre-admitted as Exhibit 12B.
Okay.
Miss Ashlock, what have I just displayed on screen?
That appears to be one of the emails.
Is it a fair and accurate copy?
Yeah, it appears to be.
Has it been altered or changed in any way?
No.
What does the email say?
As to 403, more misleading than it is probative.
All right. I think we're just laying foundation for this. Well, it's already pre-admitted. Okay.
Your Honor, may we respond?
Yes.
Your Honor, we are using this exhibit to prove motive, and motive is highly probative because as we can look at the last part of the email, it clearly says that that N Wolf over says that they will, if they ever catch any of the Ashlocks, they'll tie them up and torture them. That's clearly motive, and motive is always more probative than prejudicial.
Okay. Counsel for defense, is the objection her reading from a piece of evidence that's already in evidence or pre-admitted?
Your Honor, under Stipulation 7, while this piece of evidence is pre-admitted, we as attorneys can object as to specific evidentiary issues, one of them being 403. And while we agree with the defense, motive is always relevant. It's only relevant when they can prove by preponderance of the evidence that Nova Wölff actually wrote these emails. And they haven't laid that foundation on the record, so right now it's more misleading than it is probative.
All right. Let me kind of lay the sort of chips here. So this is an evidence, and she's just reading a part of it of something that's in evidence, and you're objecting her reading out loud something that's already in evidence is prejudicial.
Yes, Your Honor. We believe it's misleading to the jury, misleading them into believing that Nova Wölff wrote this when there hasn't been sufficient foundation laid on the record that she did, in fact.
Okay. Counsel for prosecution, last words.
Your Honor, if we look at the email, we can clearly see multiple mentions of Nova and Wölff, and was so saying that we have laid the foundation that mentions of the defendant's name are in this email being referred to, and the email itself says N. Wölff, just like the note previously said, NW. We've clearly laid the foundation that the defendant has been writing these emails, and we're trying to show the motive for this, which is not misleading to the jury in any way.
Yeah, I don't see how reading from something that's in evidence already is prejudicial. I feel like that conversation would have had as to whether or not it should have previously been pre-admitted. So I'm gonna overrule the objection on that basis.
Yes, Your Honor.
Yes, Your Honor. Now, Miss Ashlock, what does the email say?
It's basically Nova Wölff threatening us that she'll tie us up and torture us until she hears us begging to be killed.
What did you do after receiving all those threats?
You know, I stopped going out unless I had to. I even moved my pigeons indoors because I was scared someone would hurt them to get to me.
Ma'am, I know this might be hard, but I'd like to talk about the day of March 11th, 2025. Where were you at the time?
I was in Corleone because I had a task there.
What task?
I was trying to locate Jaden since I heard he was in Corleone, but I personally didn't see him anywhere.
What did you do afterwards?
I was heading back to my motel at around 10 or 10:30. The street was basically empty except for this one stranger who was a few paces ahead of me. And, you know, she kept wearing me, and from there, things escalated pretty quickly.
Well, how did things escalate?
Eventually, the stranger went to talk with the owner of a house down the street, and that's when the homeowner came outside and looked in my direction. I ignored them for the most part and kept walking until I felt something hard and cold hit my head.
What happened next?
I think I passed out. Next thing I know, I'm tied to a chair with duct tape over my mouth.
Ma'am, did you know where you were?
Not at the time. Later, Wölff came into the room with a knife and she started interrogating me about a person named Jay Kuang. That's when I learned that I was in Wölff's basement.
So what did you tell the defendant?
The truth.
What was the truth?
Well, at that time, I didn't know Jaden had changed his name to Jay Kuang, so I just told Wölff that I didn't know who he was. I'm pretty sure I had part of this conversation recorded on my phone before she smashed it against the wall.
Would you recognize the transcript of that recording if I showed it to you?
Yeah, I would.
Let the record reflect that my co-counsel will not be screen sharing what has been pre-admitted as Exhibit 2.
Okay.
Ma'am, what have I just displayed on screen?
That's a transcript of the recording on my phone.
Is it a fair and accurate copy?
Yeah.
Has it been changed or altered in any way?
No, doesn't look like it.
Miss Ashlock, what did it say on the second to last interaction?
Sure. It says, "You're no one's prisoner, but if you walk out that door, you'll be walking right into the police's hands."
What exactly did she say to you?
It sounded to me like she was not going to call the police while I was inside, but she just wouldn't untie me.
You know how long you were in the
That's
basement for?
speculation.
As to what exactly?
The witness just said it sounded to me like she wasn't going to untie me. It's speculating as to investigator Wölff's mindset.
Counsel for prosecution would say to that.
Your Honor, this is not speculation because, as the witness has said, it sounded to me. This is only calling for her own rationally based perception and not at all trying to interpret it what Miss Wölff is saying.
Yeah, I tend to agree. I'm going to overrule it.
Yes, Your Honor.
Now, Miss Ashlock, before I let you go, are you aware of your immunity deal?
Yes, yes, I am.
What does it mean if you have an immunity deal?
I think it basically means that I have to tell the truth and the truth only.
Well, if you were lying,
I may be put back into prison.
that would be all, Miss Ashlock. At this time, I have no further questions, Your Honor.
All right. Cross,
Yes, Your Honor. May I proceed?
you may.
Hello, Miss Ashlock.
Good evening.
I want to make something clear. The reason you were stopped by Miss Wölff and put in her house was because you were threatening her with a knife, weren't you?
I'm not sure what you mean by that.
All right, well, let's see if you're being truthful with what you're testifying to right now. Because it's true that you've lied at the police before.
Yes, if you're talking about the deposition.
Ma'am, you lied to the police when you told them Investigator Wölff locked you in her basement. Isn't that right?
Again, I'm not really sure what you mean by that.
All right, well, let's see what we mean by that. Stating for the record will now be screen sharing Exhibit 2. Now, ma'am, this is a recording you brought up just a moment ago, correct?
Yes, that's correct.
Now, in this recording, she never says anything about you being her hostage.
Yeah, that's correct. She did threaten me that she will call the police on me if I leave this house.
She says you're no one's prisoner.
Yeah, that's correct.
Nowhere in this transcript does it say anything about her threatening you with physical violence if you left.
No, not on this specific exhibit.
So, ma'am, what you told us a moment ago about you not thinking she wasn't going to untie you, that's not what she told you.
Well, if you look beneath that line, I said that I want you to untie me before I spill a word. She did have me tied up.
But ma'am, bringing you back to my question, she never said, I'm not going to untie you. I'm going to pursue physical violence against you, right?
Yes, that is correct.
Objection, Your Honor. Argumentative.
Also,
Your Honor, opposing counsel seems to be testifying and is clearly pointing out like the fact that the defendant never told Ms. Ashlock that they tied them up, even though the witness has already answered.
counsel for defense, what say you?
Your Honor, I'm not being argumentative. I'm simply clarifying this witness's answer to something she's previously testified to, as I believe she's being untruthful under oath today.
All right, I'm going to overrule the objection. Counsel for prosecution, you have the ability to rehabilitate. I am confused by the back and forth, though, so if we can clear what the answer is exactly, I'd appreciate that.
Yes, Your Honor. Ma'am, I want to be perfectly clear here.
Go ahead.
You told us a moment ago you believed she was not going to untie you, but she never said that in this recording.
Yes, that's correct. Not in this specific exhibit.
Moving on, earlier today you heard your attorney say that the investigator became the perpetrator, right?
Yeah, I think that's what they said.
Let's talk about if any of your inconsistencies point to you being the perpetrator. Because a moment ago you claimed that Investigator Wölff was wearing gloves, right?
I'm not really sure. Do you mean Officer Larry Capolino?
Ma'am, I'm asking about you. Are you saying that Investigator Wölff had gloves on or they didn't?
No, I don't think they had gloves on.
Exactly, ma'am. And it's true that the forensic report only showed your fingerprints on that knife.
Yes, I believe that's the case, but I'm not really sure how that happened. I'm not a forensic expert, so you'll have to ask someone else.
Ma'am, I'm not asking you whether or not you're an expert. I'm asking about the facts. The fact is only your fingerprints were found on that knife.
That's correct.
And now, I want to discuss whether those threats you brought up could be fake.
Of course. Go ahead.
We're going to paint a little picture for the members of the jury. Stating for the record, my colleague will now be screen sharing an email inbox. This is an email inbox you see on screen, right?
Yeah, appears to be so.
Right now, Mr. Bai, well, he has a draft of an email. Ma'am, in this email, there are threats. The exact same threats you said that the investigator was making against you, right?
That's correct, yes.
Now, Mr. Bai is going to send this email to me. And if we go to sent, oh, ma'am, you could tell us that the sender, well, it says NW, right?
It says N.Wölff. I'm not sure if that's what you're regarding to.
Exactly, ma'am. It says N. Wölff with the exact same initials, NW.
Yes, that's correct.
Actually, Your Honor, more prejudicial than probative.
Yeah, go ahead. How so?
Your Honor, defense is clearly trying to mislead the jury with part of an email that their own legal assistant has just sent, and I really don't see how this email has any probative value right now in this testimony.
I think the probative value is saying maybe the email may have come from somebody else and not Wölff and made it to look like Wölff. So I get the probative value. Tell me, why is it prejudicial? Why is it substantially more prejudicial than probative exactly?
Well, Your Honor, it just because someone else could have sent the email doesn't disprove the fact that it could have come from the defendant themselves. So, and the email could in fact be fake. So we do believe that this email is more prejudicial than probative because it has also not been authenticated.
Yeah, counsel for defense, what say you to the objection?
Your Honor, this hasn't met that high 403 bar for it to be more substantially prejudicial than it is probative. The probative value here is something we've been trying to prove throughout their entire case in chief, that email is fake. That the truth of the matter is the state hasn't done anything to authenticate it, whether or not it actually came from Nova Wölff's phone, whether they got an expert to look into the authenticity of it. They haven't done any of that. So it's probative to our theory that this email is fake and this demonstrative is shown to the members of the jury.
Last word, counsel for prosecution.
Your Honor, we still believe that this is more prejudicial than probative. Your Honor, opposing counsel is an attorney on the defense, which means that she has her own bias, and they're misleading the jury by using the attorney as someone else. As I said already, this email has not been authenticated by anyone. We don't even know who this is being sent to and whether this is a valid email. So I really don't see how it could not be misleading to the jury.
But I know, but I think that might be the point, that it is a fake email and that they are showing that there's an ability to send fake emails with email addresses that may not belong to the person who it says it belongs to. I think that's the point. I fully understand the point. I don't know if this is the best way of making the point or if this is a super prejudicial way of making the point, but I'm not convinced that it is substantially more prejudicial than probative. I think the question is, The fact that I guess the evidence is pre-authenticated, right? Is there a stipulation as to authenticity to this evidence?
Your Honor, may be heard.
Not this one. I know this one we're seeing it live, but to the other emails that were made and the comparison being implied here, were those original emails, other emails, considered authentic previously?
Per stipulation 3, all exhibits are authentic. However, we don't believe this is an issue of authenticity, rather an issue of the state's investigation into the email. We're not arguing that, this email was changed and altered. Rather, we're arguing who actually sent the email.
Yeah, and I guess change and altered could mean whether or not it was change and altered prior to, I guess, being arrested, or change and altered prior. What say you to that, counsel for prosecution? The authenticity argument specifically.
Your Honor, we still feel like this whole fake email idea, it should have been run through by the state's authentication, and we don't understand how this is like okay, that this evidence is permissible, being that it hasn't been authenticated, and we don't even know who's sending it or why.
Your Honor,
Okay, so as far as that, the authenticity of what I'm seeing now, I get, because it's live in front of me. I was more referring to the previous authenticity of the other emails that this is being done of a point of, right? A point of showing those other emails weren't legit. All right, I'm going to overrule the objection, and I'm going to just instruct the jury to consider it as demonstrative and give it whatever weight they choose.
Yes, sir.
Your Honor, if I could actually change my objection to a hearsay objection.
Okay, you can. Well, you don't need to change it. I've overruled it previously. You're adding a hearsay objection. What's the hearsay objection?
Your Honor, this email is an out-of-court statement, and it is being used for the truth because
what truth is it being used for exactly?
Well, opposing counsel is correct me if I'm wrong, but previously the opposing counsel was trying to prove that Miss Ashlock is not telling the truth, and the idea that this email is being shown, they're trying to prove that the email is true by asking the witness about it, and being that it's out of court, it sort of fits the hearsay objection.
Your Honor, may be heard.
Yeah, no, it's not out of court because it's happening right here in court. And that's also no truth value in this at all. I think it's just showing that emails can be sent by people who are not actually being sent from, right? The person being named is not the person actually sending it. So
Definitely.
I'm overrule the hearsay.
Our legal assistant. Oh, my apologies.
That's fine. Overrule on that ground. You may proceed. One question: was this shown as part of meet and confer?
Absolutely.
All right. And was there any objection? Was the objection preserved at that point in time?
Yes, Mr. Hong had no objections to this specific visual aid.
Okay. All right. I'm gonna overrule the objection.
Yes, Your Honor. Now, Miss Ashlock, bringing it back to my questions, it's true that right there it says N Nova Wölff, right?
Sure. It says N.Wölff.
But the person who sent this, well, it was our legal assistant, Mr. Bai.
Sure.
Mr. Bai is an investigator Wolf, is he?
No, he's not.
So he just wrote a fake email, and there was nothing stopping him.
Objection, Your Honor. Speculation.
As to how?
Your Honor, opposing counsel is asking the witness to testify on whether their legal assistant is the defendant and their motives, and this witness cannot be speculating about this.
Counsel for defense?
Your Honor, this would fall under the witness's rationally based perception under Rule 701A. as we all saw, we were all witness to Mr. Bai making this fake email, sending it out. There was no, hazard signs or anything saying, are you actually Nova Wölff sending this email? There was nothing preventing him from sending this fake email. Hence, she can testify to it without speculating.
Let's cross. If she knows, she knows. If she doesn't know, she'll tell us she doesn't know. Overrule.
Yes, Your Honor.
So, moving on, I want to talk about if you had a motive to write that note and frame her.
Sure.
Because Investigator Wölff has had tabs on your crime family for years.
Yeah, I'm pretty sure that's the case.
Ma'am, that's exactly what you would say.
I'm not sure what you mean by that.
You literally told investigators that she's kept tabs on your entire crime family for years.
Yeah, that's correct.
She made your job harder than it should have been.
Well, by threatening us, sending us notes and knives. But yeah, that's yes to your question.
Ma'am, I was specifically asking about whether or not she was consistently tracking your whereabouts, which she did.
Yeah, she did.
She was working with the police to catch your family.
Yeah, the family that I've lost the world with.
Ma'am, she even helped have the police catch you.
Yeah, that's the case, isn't it?
And after she helped the police catch you, you went to jail for years.
Yeah, that's correct.
For years, you were away from the pigeons you loved the most.
Yeah, that's correct.
Because Nova Wölff turned you in.
Yeah, that's correct.
No further questions, Your Honor.
All right. Based on that, any redirect?
No, Your Honor.
All right. Before we move on, I think we still have the objection, the conditional acceptance. I need to figure out what I'm going to do with that piece of evidence. So, argument prosecution, you said you'd laid the foundation. Was the foundation laid? And if so, how so was that foundation laid as to the handwritten note? I think I only conditionally accepted it on the condition that the foundation would be laid. So what foundation was laid exactly?
Your Honor, shortly after talking about that specific handwritten note, we also showed the email in which the same initials were shown to be N. Wölff, and we laid foundation that the defendant has in fact sent emails of the same type, which we believe is enough foundation to prove that the note was also written by them.
Yeah, counsel for defense, I'm fairly convinced that all of this goes to the weight and not the admissibility of it. I think it's similar to other emails sent. Obviously, there was motive for your client to have sent it based on other incidents that happened in the past. And it's consistent with the emails that were fairly, at least, I'm going to presume were sent by your client. So what say you as to whether or not it's not,
Okay. He's not.
it doesn't go
it's
to
not.
the weight?
My apologies, Your Honor. I believe you cut off towards
Sorry.
the end.
What say you in regards to whether or not I think it goes to weight and not admissibility? Your argument goes to weight and not admissibility. What say you to that?
Your Honor, I believe this isn't an issue of weight non-admissibility, rather an issue with the foundation the state has laid. They haven't laid the foundation up to this point that, Investigator Wölff actually wrote those emails. They haven't said, yes, I saw her write the emails. I saw her do this. I saw her do that. Simply bringing up something that's written, quite frankly, I wrote this note right here. We're going to be showing to the members of the jury later that says the exact same thing. Your Honor, we couldn't just bring this note into evidence because we haven't laid the foundation about who wrote it. And that's the case with this piece of evidence.
But you stipulated, I guess, pre-trial that Exhibit 13 would come in, and same argument goes for that, and that's already in evidence that nobody saw who wrote it, nobody know who wrote it. In fact, you did a whole demonstrative about somebody's fake could have sent it, and that's already in. How is that different from the handwritten note?
Your Honor, we believe that the email is a bit of a different story, considering that we agreed to it before trial. That fact that it was actually technology, that's another issue that our other council members have taken care of before court. But we're arguing that this wouldn't be the same exception because it's a handwritten note. Everyone on Earth can write a handwritten note. Anyone could send it to the Ashlocks. They have many enemies. It just doesn't meet that bar to be
Yeah.
in
I want to
evidence.
overrule the objection because anybody in the world can do a handwritten note just like they can do an email. And the email's in. I don't see any reason for why the handwritten note in. I don't see any distinction between the two. Obviously, you have arguments to wait all you want, but I don't. I think we've passed the admissibility bar here.
Yes,
So
Your Honor.
my ruling is that the note is in, and the jury can consider the note fully. It's fully accepted and not conditionally accepted. All right, with that, anything further, prosecution?
No, Your Honor. May this witness be excused from the stand?
They may be excused. Defense, you don't have any burden, although I guess you've taken one, so don't feel free to call any witnesses. Will you be having a case in chief, defense?
Yes, Your Honor, we are going to.
All right. You want to proceed now, or would you like a break?
We'd be amenable to a 5-minute break.
Yeah, let's take a 5-minute recess. I think we've been going strong here. Let's take a 5-minute recess. It's 10:39 in my side of the world, so let's come back at 10:45. All right, we're back. Defense, are you ready?
Yes, Your Honor, we're ready.
Prosecution, are you ready?
Yes, Your Honor, we're also ready.
All right, and I think we're waiting on juror Judge Noodleman, and then we can. All right, looks like he's here. All right, you can begin, defense.
We call Charlene Reeves to the stand. May I proceed?
You may.
Hello.
Hello.
Please introduce yourself to the folks on the jury.
All right. Hi, everybody. My name is Charlene Reeves.
Where are you from, Miss Reeves?
Oh, well, a long time ago, I grew up in Tilly, but I always say that my real home is New York City.
Why do you say that?
I worked as a taxi driver there. You could say I picked up more playbills than I did passengers.
What do you mean?
Well, the best part about living in New York is that you get to see all the shows on Broadway. Nowadays with all these gray hairs, watching musicals at the local high school with my neighbor is much more my speed.
Who's your neighbor?
My neighbor is Nova Wölff. Oh, goodness. Her family and I are cut from that same musical-loving cloth.
Miss Reeves, do you understand why you're here today?
You bet I do. I was there the night that Nova was attacked by a criminal, and I'm here to talk about it.
Well, let's talk about whether that criminal had a motive to harm her. To your knowledge, what's Miss Wolf's occupation?
Well, when she isn't disciplining her kiddos, I help babysit them, while she disciplines criminals as a private investigator.
And have you guys ever talked about her profession?
You could say that us ladies have the gift of the gab over a lot of homemade cookies and afternoon tea. She always chit-chats about our town. even these criminals, they're called the Ashlocks.
Did Investigator Wölff ever tell you anything about her history with the Ashlocks?
Yes, Nova told me that since her close friend was poisoned by the Ashlocks, she's been helping the police catch them for years.
How?
She said she would give tips to an officer, report all kinds of suspicious activity, and she even helped put some of the Ashlocks behind bars.
Moving forward, I want to see whether that criminal was the perpetrator. During the evening, what were you doing that day?
Let's see, that day, I was at our senior center, getting my rehearsal time in for our production of Annie. Just think, less hard knock lives and more hard knock hips. Around 10:30, I started heading home.
Stating for the record, we'll now be screen sharing a visual aid of events.
Okay.
After around 10:30, did anything out of the ordinary happen?
Let's see. First, I was humming show tunes to myself, but then I turned this corner and I realized that someone I couldn't recognize at first was walking towards me and Nova's house.
What did you do?
I didn't know what that person was there for. I was really scared. Thankfully, though, I wasn't too far from Investigator Wölff's house to ask her for help, so I was frantically knocking on her door.
Did she answer?
She did. She opened her door. I told her what was going on and what was wrong, and she told me to go back inside. She said she would take care of it for me.
Did she take care of it?
I had believed so. After just a few minutes, I heard someone belt out at the top of their lungs the name Ashlock.
What happened next?
Well, after hearing that, I peeked out my window and then I recognized this person as Cotter Ashlock near the door. She had this short brown hair with these cute little bangs, but she was wearing this big, dark jacket.
I want to make something clear and talk about whether or not Investigator Wölff acted inhumanely. Did it appear that she was threatening Miss Ashlock?
No, not from what I saw. She wasn't holding any weapons or gloves or trying to hold Miss Ashlock down. I just saw Ashlock freely running out the door.
Did you see her physically blocking Miss Ashlock from leaving the house?
No, she wasn't standing in front of the door or anything like that.
What did you see?
Well, I saw Nova. She said something, and instead of running away, Ashlock ran right back into the house.
How did Investigator Wölff react?
Well, it was after Ashlock ran in that I heard this pained yell from Nova saying, "You have a knife?"
What else do you hear?
The next thing I heard was Nova was commanding Ashlock real stern to stop and let go.
And that night, after hearing the words, "You have a knife," and "Stop, let go," Miss Reeves, what happened?
I heard police sirens. Let me tell you, it was music to my ears, even better than a Broadway show.
Why?
Well, it meant police were coming and the scariest night of my life was over and Nova and her kiddos would all be safe.
I appreciate your time, Miss Reeves. Your Honor, at this time, I have no further questions.
All right. Cross.
Yes, Your Honor. Good evening, Miss Reeves. I'd like to discuss your relationship with the defendant in today's case, Nova Wölff. She's your neighbor, right?
Yes, she's my neighbor.
Now, when you first moved to Corleone, Wölff had lent you packs of sugar?
Yes, what a little sweetheart.
And you thought she was a good kid.
That's exactly what I thought.
But more than that, you saw her as like your grandkid.
I did, and I still do.
You visited her often?
Yes.
And Wölff would often mention a family called the Ashlocks, right?
That's correct.
You eventually found out that the Ashlocks killed one of her best friends?
Yes, I felt really bad for her. It must have been hard to lose someone, you're so close to.
Absolutely. And that's why since then she's been working to trace the Ashlocks, hasn't she?
Yes.
In fact, Wölff moved to Corleone because she believed the Ashlocks were located there, right?
That's correct. She was tracing them.
She even helped the police arrest someone from the family named Cotter Ashlock, right?
That is exactly right.
Cotter Ashlock was then released on parole?
Yes, just before the night that this crime happened.
All right, let's shift gears to the day of the incident, March 11th, 2025. You were walking home at around 10:30, right?
Yes, just after rehearsal.
You heard someone follow you?
I did. It was a little weird. I'd never had that happen to me before, and it was dark. I couldn't see their face at first. So, yes.
And that's why you went to Wölff's house for assistance, right?
That's correct.
She told you she would take care of everything?
Yes.
And when you got back home, you heard Wölff yell the word Ashlock, right?
I did. That's when I realized things were more serious than I had thought.
You then heard a door slam?
Yes.
You saw a figure burst out of Nova's door a few moments later, right?
That is exactly right. They ran straight into the light in the street.
That you recognized as Cotter Ashlock, right? The figure?
Yes.
And it was after Wölff said something that they walked back into her house?
Yes, that's what confused me. I mean, I don't know. If I were a criminal, I wouldn't run straight into the investigator's house.
Exactly, ma'am. But, I just want to know, you saw them walk back into her house, right?
Yes, she just walked freely right back in.
And after that, you could hear them fighting, couldn't you?
I could. I heard Nova say, "You have a knife," and I heard her tell Ashlock to stop and let go.
Now, Miss Reeves, while all this was happening, you didn't call the police?
No, I wasn't sure exactly what was going on, and I didn't want to take any precautions that were wrong.
You heard them fighting, but no police?
No.
You couldn't see what was happening in Wolf's house, right?
No, I wasn't in the room where it happened.
Thank you. At this time, I have no further questions, Your Honor.
All right. Based on that, any redirect?
No, Your Honor. May Miss Reeves step down?
She may step down. Yes, ma'am. And before calling your next witness, let's just give it a moment. All right, please call your next witness.
Yes, Your Honor. Defense calls our client, Investigator Nova Wölff.
Okay.
May I proceed, Your Honor?
You may.
Good evening, ma'am.
Good evening.
Can you introduce yourself to the members of the jury?
Hello, everyone. I'm Private Investigator Nova Wölff.
Investigator Wölff, do you understand you have a constitutional right not to testify?
I do. I've been told that many times. But look, I need to set the record straight today.
I understand, ma'am. But before we get on to what the state's been saying, can you tell the members of the jury a little bit more about yourself?
Sure. I'm a private investigator, PI. But when I'm not working, I'm probably spending time with my two kids. I've got a 13-year-old and a 7-year-old at home.
How did you get into being a PI?
My papa used to tell me that there were 3 kinds of people in this world. You've got the bullies, the bullied, and the protectors. And while I wasn't big enough to bully, and I was too stubborn to be bullied, I just wanted to protect people. My kids, the people I love, my clients.
How are you qualified for your job?
I always like to say that my first field training was growing up with 3 older brothers. But professionally, I earned my credentials in criminal justice. I completed 6,000 hours of compensative investigation experience, and then I obtained my private investigator's license. It's been 22 years now of trying my best to protect my community.
Is there anyone you protect your community from?
Yes, there's this family, or better known as a crime syndicate, the Ashlocks. They're notorious in my area for all sorts of crimes. Homicide, extortion, poisoning, things like that.
Do you know any of the Ashlocks personally?
Unfortunately, I do. 5 years ago, the Ashlocks poisoned my friend, Mark.
On that note, ma'am, I'd like to talk about what the state's been saying today. Have you been here all of trial?
I have.
Did you turn from an investigator to a perpetrator after your friend was poisoned?
No, I'm a professional private investigator. I wear this badge with honor. I wouldn't perpetrate anything. I remember Mark always used to tell me, when people are safe, that's when our jobs are done. I got my justice by making sure what happened to him never happens to another person under my watch. That's my job. That's why I performed a citizen's arrest on Cotter Ashlock.
Taking a step back, ma'am, did you hear Miss Aditham in opening statements say that you acted intentionally inhumane and illegally?
I did hear that.
If that's okay with you, ma'am, I'd like to walk down those three things and see if they're true. Starting with your intention, ma'am. Was it your intention to hurt Cotter Ashlock on March 11th?
Absolutely not.
Was it your intention to get revenge?
No, not at all.
Ma'am, what was your intention that night?
To perform a citizen's arrest on a known criminal. She was violating her parole, and it was for reasons I don't even want to think about.
Today, the state says that you didn't call the police in time. Do you remember that, ma'am?
Yes, I remember.
Is that true?
Of course not. I called the police as soon as I possibly could, but it wasn't safe to immediately.
A moment ago, ma'am, did you see the timeline we had on the screen?
I did see that.
I'd like to show you that timeline again, ma'am, and we can fill in the gaps for the members of the jury. Stating for the record, Your Honor, we have that timeline back on screen. Ma'am, can you break down the series of events from your perspective?
Sure. So a little after 10:30, I just tucked my kids in. I remember Miss Reeves knocked on my door and she told me that someone was following her in our neighborhood.
What did you do?
I went outside to de-escalate the situation, and I saw Cotter Ashlock.
How did you react?
Well, first I was shocked, and then I was worried. For myself, for my kid sleeping inside, Miss Reeves, who lives alone, the people around us. So I confronted Ashlock and I told her to leave my town.
How did she react?
I remember she had this black hair. She tied it back. She was shouting at me. Then she reached into the left side of her jacket. She pulled out this giant knife, and then she lunged towards me with it.
What did you do once Cotter Ashlock lunged at you with that giant knife?
I disarmed Ashlock. I kicked the knife out of her hands. I remember it fell on the sidewalk. I restrained her and I took her to my basement.
Could you call the police at that time, ma'am?
I couldn't. I could hear the crashing sounds in my basement, and all I could think about were my kids. I had to check on Noah and Zoe first, make sure they were fine, that the house was okay before I could call the police and return to the basement.
So what happened next?
When I got back to the basement, Ashlock was throwing things around, banging against the wall, causing a ruckus. I decided it wasn't safe to call the police while this criminal was still in my house.
And so what did you do?
I had a very brief conversation with her.
Stating for the record, Your Honor, we'll be screen sharing Exhibit 2, a transcript of that conversation.
Okay.
And Your Honor, for the record, it's already in evidence pursuant to Stipulation 7.
Understood.
Ma'am, the state alleges that you held Cotter Ashlock in your basement against her will. Is that true?
No. It was safer for me to wait until she left before I could call the police. I even told her, "You're no one's prisoner," which was true because she left momentarily after.
Hold on, ma'am. She left your house?
That's right. She walked out of my basement and I followed her to my doorway.
Did you see anything?
From my door, I could see she was walking out. She walked to the sidewalk where we were at earlier. She bent over and she picked something up.
What did she pick up from that sidewalk?
It was the knife from earlier. And I remember she just charged back at me towards my house with the knife. And that's when I screamed, "You have a knife?" And stop, let go.
I'd like to talk about what happened between you screaming, "You have a knife," and the police arriving at the scene. Is there a reason you weren't able to call the police during this time?
Well, I was so busy trying to restrain her again, trying to get my kids away from her, back into the basement. It took me a while. I couldn't call the police immediately.
Did you call them as soon as you could?
Oh, absolutely. I didn't want to take an unnecessary amount of time. I tried to do everything as quick as I could.
Did you hear the state to say today that you were inhumane?
I did hear that.
I want to be clear for the members of the jury. Did you ever use violence on Cotter Ashlock after she charged back at you with that knife?
No. All I did was kick the knife out of her hands and restrain her. I I never even touched that knife. I didn't want anything like that near my house.
Why not?
All I could think about was my front door being open. My kids were upstairs. I thought she wanted to kill us, and when she pulled that knife out again, I thought I had two choices, that this was it. I was maybe gonna die, or I could fight for my life.
Investigator Wolf, let's set the record straight. Did you intend for anything except a citizen's arrest?
Of course not.
Did you ever do anything inhumane against Cotter Ashlock?
No, I did not.
Did you ever do anything, ma'am, you didn't deem necessary?
Absolutely not. When she tried to attack me, I acted in self-defense. I was careful not to do anything unnecessary. I I only wanted to protect my community, but now I don't even know anymore.
What do you mean by that, ma'am?
Well, look at me. I'm in court. I may go to prison.
Objection, Your
Cotter
Honor, as to more prejudicial than probative.
Yeah, specifically to her talking about prison.
Yes, Your Honor, as to this whole uh, uh, I mean, Your Honor, as to I like to object as to relevance. I don't believe that her statements as to if she could repeat her statement one more time, please.
I believe she's talking about going to prison and all the terrible things that's happening to her now.
Yes, Your Honor, and I don't believe any of these statements that she is making right now are relevant to prove or disprove um, any of the facts in contention in this case.
Response, Your Honor.
Yeah, specifically the prejudicial nature of this talking about prison, that's usually a bifurcated issue that goes after trial if there is a conviction, and we don't need to deal with sympathy here. What say you to the prejudicial nature of this?
Yes, Your Honor. First of all, Your Honor, under Rule 403, it has a very high bar to be excluded under that rule. And secondly, Your Honor, the importance of this statement, whether that's prison, whether that's what's happening to her right now, it all goes under her intent. From the moment the prosecution came up here, said something about her intentionality throughout this case in their statements, intent is a key part of a citizen's arrest versus an unlawful imprisonment. And in this case, Your Honor, we understand there's a concern with the bifurcation rule, but we would say that we're not going into any specifics of penalties. So right now, Your Honor, we understand we're in the guilt phase, and we're just talking about what this witness is perceiving. Nothing is going to the fact of the record of what might happen.
Your
Yeah, I'm
Honor,
gonna
if I may
sustain the
respond.
objection. It's fine. I'm gonna sustain the objection. I'm not sure what her intent about how she feels after the fact has to do with why she did what she did before the fact, allegedly what she did. So, and again, that's very improper for a witness to comment on punishment before the penalty phase. So I'm gonna sustain the objection.
Yes, Your Honor. Ultimately, ma'am, can you tell the members of the jury why you did what you did that night?
I was trying to protect my community. My kids are the center of my world, and I'd hate for them to be living in a neighborhood where they can't even trust if they can go outside at night. It's horrible.
Thank you, Investigator Wölff. Your Honor, at this time, no further questions.
Okay, Cross.
Yes, Your Honor. Good evening, Miss Wolf.
Good evening.
I want to talk about whether you told the police the whole truth. Do you remember being interviewed by Officer Capolino on March 12th?
I do remember.
Would you recognize a copy of the transcript if I showed it to you in court today?
I would.
Your Honor, let the record reflect, we'll be screen sharing what has been pre-marked as Exhibit 1B.
Okay.
Do you recognize this exhibit?
I do. That's that interview transcript.
And is this a fair and accurate copy?
Looks like it.
Your Honor, let the record reflect that Exhibit 1B has already been entered into evidence.
Okay.
Miss Wolf, you stated that Cotter Ashlock had chosen to stay at your house on her own free will, correct?
That's right.
You refused to elaborate on how Ashlock had gotten into your house, correct?
Right, it was just an interview with Detective Capolino.
Is that a yes to my question?
Yes.
You refused to explain how long you had locked Ashlock in your basement?
Right.
And you didn't clarify to Officer Capolino whether she had trespassed or was detained outside, yes?
I didn't think I had to. I didn't.
Now, Miss Nova, you remember being recorded by Miss Ashlock while she was detained by you, yes?
I do remember that.
Would you recognize a copy of it if I showed it to you in court today?
I would.
Your Honor, let the record reflect that we'll be screen sharing what has been pre-marked as Exhibit 2.
Okay.
Do you recognize this exhibit?
I do. That's the recording.
And is it a fair and accurate copy?
It is.
Your Honor, let the record reflect that Exhibit 2 is pre-admitted.
Any objections? Oh, it's pre-admitted. I'll allow it. Wait, wasn't that already in evidence? I think you
Yes,
all
Your
already
Honor,
brought
it is
this
already in evidence.
Okay. You may proceed. Apologies.
Yes, Your Honor. Miss Wolf, you only threatened to call the police, yes?
Right. Yes.
And you asked her some questions, correct?
Yes. I wanted to know why Ashlock was breaking her parole and wandering about in Corleone. Yes.
You planned on asking some more questions afterwards, correct?
Sure.
And this recording happened between 11:17 and 11:20, right? Right?
Yes.
Now, Miss Wolf, let's go over the statements you made on your 911 call. Would you recognize a copy of it if I showed it to you in court today?
I would.
Your Honor, let the record reflect we'll be screen sharing what has been pre-marked as Exhibit 4C. Do you recognize this document?
I do.
And is it a fair and accurate copy?
Looks like it.
Your Honor, motion to enter Exhibit 4C into evidence.
Any objection?
Yes, Your Honor, as to hearsay, specifically Officer Capolino's statements.
All right. Response to hearsay as to. All right. First, let's go back. First, to 4C. Any objection to 4C?
Your Honor, the objection of hearsay for Officer Capolino's statements goes for both of them.
Yeah, I don't think there's an Officer Capolino on 4C. I see dispatch. I see Wolf. So go ahead.
Your Honor, in that case, it also be objected to dispatch.
Okay, so we're objecting to dispatch. So what say you in regards to 4C, counsel for prosecution?
Your Honor, we believe that in this case, dispatch is only asking standard 911 questions that you would expect to receive after calling and have no truth value that pertains to this case.
Let's see. Last response, counsel for defense. I'm looking at dispatch, and they all seems to be questions, and they're saying there's no truth value to these questions. What say you to that response in regards to 4C?
Your Honor, we would say that although the majority of them are questions, there are statements such as, we will dispatch a few units immediately. Your Honor, statements like that, that's certainly not a question.
Yeah, but then that goes into maybe plan or intent under 8033, maybe, and it's just one statement. So I'm going to overrule the objection on 4C as to dispatch. Counsel for prosecution on 4B, what say you to Wölff's statements?
Your Honor, we aren't entering Exhibit 4B yet, and we would like to redact the right side of the screen to the jury as of right now.
Okay, all right, then 4C's then.
Yes, Your Honor. Now, Miss Wölff, you claimed to dispatch that Cotter Ashlock had trespassed on your property, correct?
That's right.
And the approximate time you placed this call was at 11:35, correct?
Yes.
Let's jump back 45 minutes before to your call with Officer Larry Capolino. Would you recognize a copy of it if I showed it to you in court today?
I would.
Your Honor, I would like to direct the court to the right side of the screen. Do you recognize this document?
I do. That's that call.
And is it a fair and accurate copy?
It is.
Your Honor, in motion to enter Exhibit 4B into evidence.
Objection? You still maintain the same objection, counsel for defense?
And no, Your Honor, we're prepared to redirect on it.
All right, so I'll allow for 4B in.
Yes, Your Honor. Now, Officer Capolino had issued a direct warning to you to not get involved, correct?
That's right, but as a private investigator, I don't have to follow Officer Capolino's orders. But yes, she did tell me that.
Of course, investigator. This happened at 10:50 p.m., right?
That's right.
Meaning between this call, the recording made by Miss Ashlock, and the 911 call you officially made, you knew Ashlock's exact location for at least 49 to 18 minutes, correct?
That's right. Ashlock had been in my basement for quite a while, but because he was causing so much ruckus, banging against my wall, throwing things around, I didn't think it was safe to call the police until 11:35 p.m. But yes.
So, Investigator Wölff, just to clarify one last time, you knew Ashlock's exact location for 49 to 18 minutes, correct?
That's right.
You did not call the police in this time?
I couldn't.
Is that a yes to my question?
Yes, I couldn't call the police at that time, yes.
Thank you, Your Honor. No further questions.
All right, with that, any redirect?
Yes, Your Honor.
All right, you may proceed.
Investigator Wölff, Mr. Hong just asked you a lot of questions on how you didn't follow Officer Capolino's orders. As a private investigator, are you required to?
I'm not required to. As a private investigator, we're not necessarily law enforcement, police officers. Officer Capolino isn't my boss, per se.
To your knowledge, ma'am, after Cotter Ashlock was released on parole, was the police doing anything to find him?
To my
Objection,
knowledge,
Your Honor. As this is outside the scope of the redirect.
Response, Your Honor?
Yeah.
Your Honor, opposing counsel previously published an article, or rather an exhibit to the members of the jury. In the article, it clearly says, we know Cotter Ashlock has been violating his parole. It was in the exhibit opposing counsel entered. Your Honor, we believe that gives us leeway under this jurisdiction to ask this witness about it.
Last
Your
word,
Honor,
counsel for prosecution.
Your Honor, we believe that brief mention of um, knowing that Cotter Ashlock had violated his parole does not give opposing counsel leeway to pursue this line of questioning.
Your Honor, response?
No, I'm gonna give you a little bit of latitude. I think we're also playing with speculation. I don't know how she would know what the police did. But since you just see if you can tie all that together and lay the foundation, I'll overrule for now, without prejudice, to bring back the objection.
Yes,
Your Honor.
Investigator Wölff, how did you know that Cotter Ashlock had violated his parole?
I mean, in my line of work, the Ashlock family, they're very notorious. I'd seen it on the news before, and while I was doing research for my clients.
So during that research, ma'am, after you knew he had violated parole, did you see any news he was caught?
No. It wasn't until I turned Ashlock into the police that I knew anything about that.
So I want to make this clear, ma'am. Who was the one who finally turned that criminal into the police?
I was the one who turned Ashlock in, who finally called the police, who finally found him.
Thank you, Investigator Wölff. Your Honor, at this time, no further questions.
All right. Based on that, any recross?
No recross, Your Honor.
All right. Anything further, defense?
No, Your Honor. With that, we rest our case in chief, and we know it's getting late for a lot of our judges, so we can head straight into closings.
Okay. Let's head straight into closings.
Your Honor, permission to proceed?
You may.
Members of the jury, the investigator became the perpetrator. It's March 11th, 2025, and Cotter Ashlock, a former member of the notorious Ashlock crime family, is roaming the streets of Corleone. He's out of power, he's out of resources, and he's out of friends. And as if it couldn't get any worse, he's kidnapped by the defendant, Detective Nova Wölff. At first glance, it looks like a civilian is doing her part to society by locking up a dangerous criminal. However, the defendant's motives are a little less pure. You see, several years earlier, Jaden Ashlock, another member of the Ashlock crime family, killed one of Detective Wölff's close friends. Afterwards, the defendant hunted down the Ashlocks. But Jaden Ashlock testified against the Ashlocks and was placed under witness protection, and it seemed as if the defendant would never get her revenge. Until fortune lands one of the only people in the world who knows Jaden's location directly into her hands. Not only does she tie him up and interrogate her immediately, she intentionally confuses the police with vague and unhelpful answers. Now, we, the people, have proven the defendant has committed 2 crimes today. She, without a warrant, restrained a person against her will, committing unlawful imprisonment, and she interfered with an officer by giving vague, unhelpful responses to her questions. We've proven on 3 counts that it was intentional, inhumane, and illegal. Firstly, it was intentional. According to Cotter Ashlock's testimony, she was forcibly taken to the defendant's basement, tied to a chair, and interrogated. Furthermore, from the defendant's call to Officer Capolino, to the timestamp recording on Miss Ashlock's phone, to the defendant's 911 call, the defendant had at least 15 to 20 minutes to notify the police with Miss Ashlock's location, yet didn't. The defense claims that the defendant was making sure that everything was tied down. The defendant was already aware that Miss Ashlock was violating parole. The defendant arrested her because she was violating parole and because she was trespassing. Does it really take upwards of an hour to pick up the phone and call the police? In addition, when questioned by Officer Capolino, the defendant gave vague answers that clarify nothing. She didn't explain how she had gotten Miss Ashlock into her basement, didn't explain how long she held her in her basement. She didn't clarify whether Miss Ashlock was trespassing or detained outside. While it is entirely within her Fifth Amendment rights to give no answers, it is not within her rights to give vague, misleading answers. Furthermore, the defendant already had the victim in her basement while on call with the police officer, who specifically asked for information. Not only did she withhold the information, she lied about not knowing anything. Secondly, it was inhumane. Jaden Ashlock was innocent in the eyes of the law and was given an opportunity to move on, but the defendant decided she was above the law and wanted her revenge. She ran the risk of revealing Jaden's identity, then kidnaps Cotter Ashlock, locks her in her basement for at least an hour. She claims that Miss Ashlock had trespassed, but not only does Miss Ashlock have no reason at all to do that, she contradicts her own statements by saying that Miss Ashlock was just following Miss Charlene Reeves, who didn't. Now, let's put aside the legal issue in all of this. Detective Wölff, despite her claims on direct, tied up Miss Ashlock, then made things up for the trial, because none of the statements she made are on official documents. Her only defense is trying to make you feel pity. Thirdly, it was illegal. According to Permit Office Enforcement's v. Citizens for No Permit Office Enforcement's 1999, in Tilly, motive also has to be considered in an affirmative case for citizens' defense. Restraining a person with no or minimal intention of stopping a crime is not an act of citizen's arrest. Now, we have laid enough foundation of proof that the defendant's motives were not pure. The defendant didn't arrest Miss Ashlock because she was violating parole or because she was trespassing. She arrested her because of revenge. In addition, Tilly v. Foundation for Poisoning Pigeons 2025 states that to interfere with an officer, the false statements must obstruct the officer's ability to continue with the investigation. We have additionally shown how this is the case. The defendant didn't invoke her right to remain silent. She purposely gave confusing, frustrating responses, outright lied to the police. This is interference. The defense claims the investigator stopped the criminal to stop the crime. But we have given enough evidence to show that the investigator became the perpetrator and committed another crime herself. Members of the jury, we the people have the burden of guilty beyond reasonable doubt. We have to prove the defendant illegally detained Miss Ashlock while lying to the police. However, the defendant took their own burden when they had to prove that what the defendant did was indeed a citizen's arrest. We have shown you today how this is not the case. The greatest piece of evidence? Bruises on Miss Ashlock's knuckles and the unreliable word of an investigator with their freedom on the line, and they take it at face value. With all the evidence in mind, we ask that you make the only just verdict here today. Find the defendant guilty. Thank you.
All right, defense.
Yes, Your Honor.
May proceed.
She captured a criminal to stop her crimes. Mr. Hong just told you that the investigator became the perpetrator. But you learned today Investigator Wölff didn't turn into a perpetrator. She was forced to be a protector. Because when Cotter Ashlock, a criminal, broke her parole, went to Investigator Wölff's house holding a knife, threatening her, about to kill her, you learned today Investigator Wölff did what she had to do to protect her community, to protect her kids, to protect herself. Members of the jury, the investigator didn't turn into a perpetrator. She captured a criminal to stop her her crimes. But when the state wanted you to turn Investigator Wölff from a mother and a protector of her community to a convicted felon, well, they've taken on the most difficult burden of any prosecutor in any jurisdiction for any crime. It's called proof beyond a reasonable doubt, which means by the end of this trial, if you have a single reasonable question about what happened, Investigator Wölff isn't guilty. But Mr. Hong didn't tell you this. There's two burdens going on today. Because when Miss Garcia and I saw that these prosecutors charged Investigator Wölff with unlawful imprisonment, we knew that wasn't the case. We knew that she captured a criminal. That's why it happened. Which is why we've taken on an affirmative defense today known as citizen's arrest. Under that, we had to prove to you three things. 1, Investigator Wölff witnessed a crime. 2, she used reasonable force. And 3, she called the police within reasonable time. And unlike the state, we didn't have to prove that to you beyond a reasonable doubt. We just had to prove that to you by something called a preponderance of the evidence, meaning more likely than not. And we've done that today through 3 facts: the crime, the capture, the contact. And so first, the crime. Did Investigator Wölff witness a crime by Cotter Ashlock? Today you learned the answer is yes. Not only did every single person you see on that stand testify that Cotter Ashlock broke her parole, but you also heard that she was holding a knife. Holding Investigator Wölff at knife point. And when that happened, you learned Investigator Wölff exercised her legal right as a citizen, like you and me. A right that we all have. But members of the jury, you don't just have to take it from me. We know that Cotter Ashlock was committing a crime because of the knife that only had her fingerprints on it. Now, no matter how much the state's detective said in one breath that she wore gloves and one breath that there were no gloves, well, members of the jury, you can hear it from the state's own eyewitness, Cotter Ashlock. Even Cotter Ashlock had to tell you there were no gloves. And so, members of the jury, I want to take you back to an old case from a long time ago. A long time ago, there was a famous saying. It's called, if the glove doesn't fit, you must acquit. Members of the jury, we have a similar situation here. The prosecution claims there was gloves in one breath, no gloves in the other. Members of the jury, if that glove doesn't exist, you must acquit. But the second thing here, the capture. Did Investigator Wölff use reasonable force? And today you learned, unlike Mr. Hong wants you to believe, that doesn't mean waiting until she's pleading out on the street. That doesn't mean she's being as gentle as possible. That means she did what was necessary. And today you learned that when she was held at knife point, when she thought her life was being threatened, she tied Cotter Ashlock up. Members of the jury, you don't just have to believe reasonable force because of my words. You can believe it from the medical report that you saw by Detective or other Officer Capellina. That right there said bruises to the knuckle that indicate punching, but not punching by Investigator Wölff like they want you to believe. Punching by Cotter Ashlock. Because you learned today that she was trying to commit a crime, and Investigator Wölff had to stop her. And so the last thing, that's the call. Because today you learn Investigator Wölff called within reasonable time. Because that doesn't mean immediately. That means as soon as possible. And you learned today when Investigator Wölff, she knew she was safe. When that criminal was calm and when her kids were okay. She called the police as fast as she possibly could. And so let's talk about what the state's been telling you. Because they want you to believe that she acted intentionally, inhumanely, and illegally. Members of the jury, this case hinges on one thing. That interference charge, that imprisonment charge, it hinges on what Investigator Wölff's intent was. Today you learned that intent. That was a citizen's arrest. The prosecution tries to tell you about a murder that happened years ago, but members of the jury, how many times did you hear about that today? Not a lot. Because that isn't the reason Investigator Wölff captured. The reason she had to capture that criminal, the reason she became a protector, that was because of Cotter Ashlock. Members of the jury, today you learn it was Cotter Ashlock who intentionally broke that parole. Cotter Ashlock who acted inhumanely to Miss Wölff, inhumanely by lying to you, and ultimately members of the jury. Miss Wölff didn't do anything illegal. She was trying to prevent it. That's why we're going to ask you to find her not guilty. Because she captured that criminal to stop her crimes. I appreciate your time.
All right. How much time does prosecution have for rebuttal?
Your Honor, I don't have a rebuttal here today.
All right, no rebuttal? Okay.
Thank you all so much for a fantastic round. Kicking it off to our judges for some final highlights. We'll begin with Judge Ross.
I hate going first. Okay. I wrote like a lot of very specific comments. There weren't a lot of general stuff that I noticed a lot of y'all didn't do. I just want to start out by saying great job, everybody, though, especially the witnesses. You would be surprised by how many people that do mock trial can't make their witness sound like an actual person, and y'all did really well at that. A big thing I noticed was like the themes. You guys all had themes, such great first step. A really good thing to do would be to try to like incorporate your themes throughout your directs and even your crosses if you could. But really great job bringing that up in like the opening and the closing, and using the other team's themes against them. That's really great. Yeah, just try to like incorporate that throughout the direct and cross if you can. Work on the objections a little bit, because I think y'all misunderstood some of them, or like weren't phrasing them quite right, or didn't have a great response for them. Yeah.
Thank you so much, Judge Ross. Judge Noodleman.
Yeah, no, this was a very entertaining round. I didn't understand, to be frank with everybody. There were a lot of hearsay objections that people didn't raise, and I didn't understand why. And I say that because, I say this a lot of times when I'm judging mock trial. I don't think you get points for saying no objection or conceding a point. I think, on the other hand, you'd be surprised because, as I've often, say, well, what's the basis of the objection? And, the other side either misses it or doesn't point to the right rule, or they get hung up with it. But you're taking that off the table. There were just some things, prosecution says Cotter Ashlock broke parole. I wrote, why isn't that hearsay? I mean, there were things that were just went on. And then Ms. Liu was very compelling on, I guess, the defense of the defense cross of the prosecution first witness. She misstated Exhibit 9, about the contusion to the knuckle. I believe it says in the exhibit he could have caused it. Miss Liu said it did cause it. Now I am listening very closely to what all is being said, but that would have, if someone had objected to that on the prosecution side, boy, Miss Liu would have had a hands full. Okay, but so you gotta one of the things, the real skill in this thing, and same with real trials, is you've got to hang on every word and listen to what everybody is saying, because somebody took Miss Liu's credit, she got that in there, and it went right in. And Mr. Hung, when you have somebody like Miss Liu on the other side, you got to protect your witness a little bit, because she was, having her way, smacking him around. You got to, step up and, object if she's beating up on your witness. There's definitely could have been objections that would have been raised. Now, you also got to be familiar with these stipulations, because I read that stipulation. As you know, for anyone who's dealt with me, whenever somebody says something, I always look at it, because if you think I remember all the rules and all the stipulations, all these things by heart, you're kidding yourself. But if you look closely at that stipulation about the pre-admitted exhibits, it very specifically says that you are preserving your rights if something is prejudicial. And I would have, emphasized that over and over again, because Judge Simon, to his credit, had his hands full dealing with all this stuff. He was originally taken with the fact that it was admitted. And that wasn't necessarily the be all and end all of that stipulation. Could have made a stronger argument about that. I liked the idea. As far as Exhibit 7, okay, no one objected on it being hearsay. I would have said that was hearsay, Exhibit 7, because then you would have forced them into laying the foundation. Why isn't a note that says NW? Why would that not be hearsay? Somebody could have argued. Nobody argued that that note was hearsay. And then you'd have to get them to somehow, it would come out that there's no foundation for that. Okay. And then that would have forced the issue a lot quicker. Instead, you let the issue wound up languishing until ultimately Judge Simon allowed it in. And that's what happens, because that was like put off on the back burner. But I liked the gloves. I thought that was a very compelling thing. And I thought the email was a fascinating demonstrative exhibit. I would have made it clearer, because it wasn't completely clear to me until it was ultimately mentioned by Ms. Garcia that was a demonstrative exhibit. I would have said, we're doing this email as a demonstrative, okay? Because, and that's what raised the issue of whether it was raised in the captain meeting or not. But I did like the fake email. I thought that was a good tactic. But ultimately, probably the only ruling I would have parted company with Judge Simon on would have been the note. But that would have been assuming somebody had raised the issue of it being hearsay and forced the thing out. Because if it would only be a party admission, okay, or a statement of a party opponent if a foundation was laid to show that it came from NW. But that didn't happen. So you can't get that exception to the hearsay unless that foundation got laid. That would have been, to me, how I would have dealt with Exhibit 7. I liked Miss Reeves. I thought she was a very entertaining witness. I did find that she was very credible, and I also thought that the investigator was very credible, very passionate. It's a very interesting role, because in some level you got to be serious and show your, taking your job as the protector very, very seriously. And lastly, I was very much taken by Ms. Liu's. That might have been my highlight, Ms. Liu's closing. I thought that was an outstanding closing. There's really no other way to describe it. And, Mr. Hung, you were right up there, and I was following you along. I do think, just by way of optics, it's always nice to have the last word. So you have the opportunity for a rebuttal, even if it's 10 to 20 seconds. You've got the last word before the jury goes to deliberate. You really don't necessarily want to pass that up. You know what I'm saying? Just as a practical matter. But it was a very enjoyable trial to watch all around. And thank you very much for putting on a good program to watch.
Thank you, Judge. Judge Simon.
All right. Congrats. This was a high-level round. I apologize if I pushed you all a little bit on the rules of evidence. I found them very interesting, and I think it's pretty cool. But I think I said 105, but I think it's 104. It's actually a really cool rule where you can allow the court to conditionally accept something. But the coolness of it is you don't wait for the judge to bring it back. After the conversation's over or the foundation would have had to been laid, you got to jump back on, Your Honor, assuming we're outside the presence of the jury, foundation hasn't been laid. We've not heard of this, and that. So it's a cool rule to take advantage of, I think, both sides. And you got to know when to jump back in, right? You don't want it to you don't want me to bring it up. You don't want it to kind of be out there like a hanging chad. Something I think it's sort of a pet peeve of mine. You make an objection and then you don't even argue it and then you change it to something else, right? That's telling me there's a lack of confidence in what you're saying. There's a lack of you're afraid of the battle, right? You don't want to change your objection. Now, you don't want to change your objection before making the argument. Now, if there's an argument they make, right, and they bring sort of an issue, that's also objectionable. Then you can say, then judge, this things they brought up is also objectionable under this other rule. Now, I'm not changing it. I'm just having a deeper conversation about what the issues are. But to just kind of say something and then change it to something else immediately makes me kind of lose faith and confidence in what you're saying. Let's see. I've got a lot more specific notes, but my highlights I think were the crosses. I thought the crosses were really good. The flips, I mean, there were a lot of flips. Flips starting with some of the. I think there were a lot of flips, but not the flips of the other side on your direct and crosses, but not like a lot of theme integration as part of your case in chief, right? Or maybe signposts and segues. I think using your themes, especially, or your roadmaps, right? Your themes or your roadmaps that you have in your opening as segues and signposts is really, really good. Almost as good as flipping the other side, right? I think you kind of flip the other side and made them your signposts and segues, which I thought was really, 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 really effective to be responsive. But you don't want to lose sight of what you're also pushing in the story you're also telling. And I thought the remind me, I don't know, of a case from like 5 years ago about somebody who sent an alert or something, and then there's like a whole website where you can change it. So I thought that demonstrative was really that was probably the highlight, that demonstrative of the email and sending it. I kind of want to know how you do that in real life so I could spam people. But that was, I thought, really cool, thinking outside of the box, right? Things other people aren't doing. I feel like there's going to be 100 different trials, so if you can find different creative ways of telling the story, that's what you want to do. And I thought that was a really cool, creative way of proving a point. You're literally, I say it's good to tell me, it's better to describe it to me. It's best to demonstrate it to me, right? So those are sort of my rules of advocacy. So if you can demonstrate to me what happened, that's the best rule of advocacy. And I couldn't think of a better way of demonstrating the point you were making. You weren't just telling me, you were literally showing me. And I think that's the highest form of advocacy. So that's probably my highlight. Everything else was really, really, really good as well. So good job, guys.
Thank you all so much for the recording. And to build up a little bit of drama before the announcements, this team has faced the other team several times in recent contests. Most recently, it resulted in a split decision. The prosecution had made the semifinal round at our last contest. And again, they're here in semis. The defense had not made the semifinal round at the last contest, but had won the tournament prior to that. So this is a very interesting back and forth. And as befits such a contentious back and forth, we have a split decision for witnesses that is unresolvable. 3 different witnesses each got a separate vote. So acknowledging the triplet co-MVP witnesses from the prosecution, Miss Skylar Chen. From the defense, Miss Lily Kizirian. From the defense, Miss Krystal Deng. That takes us to the attorneys. This was a split decision, but it is resolvable. Winning the majority of votes in the semifinal round. From the defense, Miss Elizabeth Liu. That takes us to the final announcement. Of course, you'll get your ballots just about immediately after it is announced. Congrats to both teams. Advancing to the final round, top 2 out of 48 is the defense. Well done to all. Congratulations.